Good afternoon, everyone, and welcome to this FedSoc Forum webinar, Political Violence as a Threat to Judicial Independence and the Rule of Law. My name is Robert Smith, and I'm the General Counsel for the Senate Commerce Committee. As a reminder to our listeners, all opinions expressed are those of our speakers and not of the Federalist Society. I'll begin by introducing today's moderator, who will then introduce our distinguished legal panel. After the panel discussion, there will be some time for audience questions. We ask that you submit them via Zoom's Q&A feature, not the chat, and that they are pertinent to the topic at hand. Our moderator today is Claire Murray, the Vice Chair of the U.S. Sentencing Commission. Before her confirmation to that role, she served in the Department of Justice as Acting Associate Attorney General and in the White House Counsel's Office as Special Assistant to the President and Associate Counsel. Earlier in her career, she was a partner at Kirkland & Ellis and a prosecutor in the criminal division of the Department of Justice. She clerked for Justice Samuel Alito and for then Judge Brett Kavanaugh on the DC Circuit. Ms. Murray holds multiple degrees, including a JD from Yale Law School. Claire, thank you so much for joining us today and for moderating our discussion. The floor is yours.
Oh, thanks so much for the introduction, Robert. I'd like to start by introducing our distinguished panelists, Carrie Campbell Severino and Rachael Tucker Wyrick. Carrie Campbell Severino is the president of the JCN and co-author with Molly Hemingway of the best-selling book, Justice on Trial, The Kavanaugh Confirmation and the Future of the Court, widely regarded as the definitive account of the Kavanaugh confirmation. As a go-to expert on the confirmation process, Mrs. Severino has been extensively quoted in the media. She regularly appears on television, including Fox, CNN, MSNBC, C-SPAN, and ABC's This Week. Ms. Severino has testified before Congress on constitutional questions and briefed senators on judicial nominations, and regularly files briefs in high-profile Supreme Court cases. She was a law clerk to Supreme Court Justice Clarence Thomas and to Judge David B. Santel on the U.S. Court of Appeals for the D.C. Circuit, and is a graduate of Harvard Law School, Duke University, and Michigan State University. Rachael Tucker Wyrick is a partner at the law firm of Consovoy McCarthy, where she represents clients in a variety of matters involving constitutional law, administrative law, congressional and other government investigations, and commercial litigation. Prior to joining Consovoy McCarthy, Ms. Wyrick served as an assistant United States attorney in the Eastern District of Virginia, where she prosecuted cases involving domestic and international narcotics trafficking and money laundering, white-collar crime, material support of terrorism, and export control and sanctions violations. Earlier in her career, she was a counselor to Attorney General Jeff Sessions and served as senior counsel of the United States Senate Permanent Subcommittee on Investigations, where she led a number of congressional investigations. Ms. Wyrick also previously served as Deputy Chief Counsel to the Senate Judiciary's Committee's Subcommittee on Administrative Oversight in the Courts. She earned her JD from the University of Alabama School of Law and BA from Auburn University. Carrie and Rachael, thank you so much for joining us today. They're here with us to discuss the threat to judicial independence and the rule of law posed by political violence. It seems like the news lately is full of political violence, whether it's the assassination attempts on then candidate Donald Trump, the violent attack on Paul Pelosi when the husband of the then Speaker of the House, Nancy Pelosi, or the recent assassination of Charlie Kirk. And the judiciary has become a particular target. So judicial security is absolutely the top priority for the Judicial Conference. Many judges have spoken out about threats that they have received. And the particular impetus for this panel is last week's sentencing of defendant Nicholas Roske. Roske attempted in 2022 to assassinate Justice Brett Kavanaugh as a way of changing the outcome of the then pending Dobbs decision and of changing the orientation of the court more generally. So just kind of as a refresher for folks about where we were in 2022, in May of 2022, there was an unprecedented leak at the Supreme Court. While the case was still pending, a draft of the majority opinion in the case Dobbs versus Jackson Women's Health Organization, which was the case that eventually overturned Roe versus Wade, was published in Politico. Over the next month, defendant Nicholas Roske, a California man who wanted to stop the draft opinion from being issued and stop Roe versus Wade from being overturned, purchased weapons and visited a gun range to learn how to use them, discussed with friends online how many Supreme Court justices he would need to kill in order to change the orientation of the court, and researched topics such as sniper techniques, ways to break into a residence and avoid detection, how best to kill with a knife, how best to restrain a victim, and which countries extradite defendants to the United States. In June, Roske flew from Los Angeles to Dulles with a knife, a gun, ammunition, a lockpick set, a hammer, a screwdriver, pepper spray, duct tape, various other equipment, and the addresses of 4 Supreme Court justices pinpointed in his GPS. He took a taxi to Justice Kavanaugh's home with the intent of killing the justice and as many as 2 other justices. Fortunately, when Roske arrived at the justice's home around 1 a.m., he encountered 2 Deputy United States Marshals and abandoned his plan. He eventually called 911 to turn himself in and cooperated with law enforcement. He ultimately pleaded guilty to attempted assassination of a justice of the United States. This past week, Roske, whose guidelines range was 360 months to life, received an 8-year sentence. Our panel of experts is going to offer us insights on the Roske sentencing and on the ways in which political violence threatens judicial independence. Rachel, I'm hoping to pose my first question to you. As a former prosecutor, I'm hoping you can give us some context. What's your sense of the severity of this crime?
Well, first of all, the seriousness of the offense is one of the first and main things that a court should consider when determining an appropriate sentence. And here, planning to assassinate a Supreme Court justice is about as serious of a crime as I can imagine, not only because it's planning a murder, but because that murder would be taken out for the purposes of attacking a critical government institution. So this is incredibly serious. It's potentially devastating, not just for the justice himself and his family, for the entire country. So it's and the level of planning here was extensive. The seriousness of this offense isn't just the end goal. Roske took some unprecedented steps. It wasn't just even though his internet searches were extensive and incredibly troubling, as you mentioned, searches about access to firearms, searches about other means of homicide, strangulation, and stabbing. I mean, very serious searches that are really troubling. But he took affirmative steps to put that plan into motion. He purchased a firearm. He had to go back a week later to pick up that firearm. He bought a plane ticket. He didn't take his original flight because he missed the cutoff time for checking a bag. So he rescheduled, he rebooked the flight. He taped cloth onto the bottom of his shoes so that any sound that it made would be dampened. I mean, this is a calculated individual. And I think that the way that I think the court took into account this individual's essential confession or turning himself in, but even that is I think incredibly calculated. The fact that he did that upon arrival to the residence, upon seeing these deputy marshals, realizing this wasn't going to go the way he planned, and then turned himself in. So, and his efforts to delete the copious evidence against him just shows consciousness of guilt. I really don't think there can be anything more serious than what we have here. And the after effects of this are already being seen. The government in its sentencing paper referred to copycat crimes. The justice has received a letter referencing Roske's attempt and indicating a wish of death on the justice. We saw reports on Sunday of an individual being arrested at the Red Mass in DC for possessing explosive materials. So unless there is a really strong message sent, I'm afraid that this sentence is not going to have the effective deterrence we'd hoped and that the justice deserves.
Could you walk us through the Roske sentencing a little bit about I know it was a lengthy proceeding. It seems to have made a lot of news. Why has it made so much news?
Right. Well, the number one reason it made a lot of news is just because of the sentence itself. It was a pretty incredible downward departure. The guidelines range here was 30 years to life. That was with or without the terrorism enhancement, which the court essentially ignored. And instead, the defendant got 8 years, and having served already, I believe, 3, with 5 left on the table and approximately 15% of that going away for good time credit, you're looking at a very lenient sentence considering the nature of this offense. Again, we talked about the seriousness of it. The 3553A factors, it doesn't seem like this sentence really is tied very closely to those factors. Certainly the need to promote the respect for the rule of law strongly favors a sentence of at least 30 years, which is what the government sought. This entire crime was born out of a lack of respect for the rule of law at a fundamental level. So imposing a sentence that reflects that severity was really important and didn't happen. You're looking at general deterrence, you're looking at specific deterrence. Here, again, we've already seen that somebody planning on the assassination of the head of a branch of our government if successful, could have altered the course of our country. And we're already seeing other threats, like I mentioned, the red mass. And the government paper cites some Marshall stats that say that threats to federal judges have increased dramatically. So certainly general deterrence was warranted here, warranted an increased sentence. And specific deterrence. Look, you're looking at an individual who has a history of mental health challenges, but his own sentencing paper stated that doesn't excuse his conduct or his behavior. He was on medication at the time. That didn't seem to change anything or prevent him from engaging in this conduct. So it's hard to say that you know that this sentence is going to offer specific deterrent to an individual who already had a certain level of support and chose to engage in this activity anyway. And if he wasn't successful this time, maybe he will be another. But it seems as though incarceration, and certainly a long amount of it, I think, is required for the specific sentencing that the 3553A calls for. Protecting the public from this individual. So all those things, and it struck me, this sentencing, to really, the victim here is, the justice. But it almost seemed as though the defendant was treated more like a victim, and like their feelings were more front and center than the actual victims in this case. So, the judge did go below the guidelines range significantly. I think a lot of what has made news is reference to Roske's transgender status. I think the court actually inquired as to whether or not the defendant's transgender status should play a role or impact his sentencing at all. Again, to the extent that that's related to mental health, certainly there is no insanity defense. I think very early, one of the earliest status conferences in this case, the defendant's counsel said that they had no concerns about the defendant's competency. So there was no evidence, as far as I'm aware, that would warrant a departure like this, that excused the defendant's conduct in any way. So looking at that the way the court did has, is cause for concern, and has a lot of people up in arms about it, and understandably so.
Thanks, Rachel. After Roske's sentencing, the Attorney General immediately announced that the department would be appealing. How common is that? How would you gauge the prospects of the department's potential appeal?
Right. Well, appeals are considered very carefully. Not every, sentence that the government isn't happy with is appealed. But in certain circumstances, when there's a significant interest in having that overturned or having that looked at more closely, the department will do that. And there's certain process that goes through a high level of oversight to make sure that they're appealing something that the leadership feels is warranted. So clearly they felt that here. Because of the downward departure, you're not looking at, there's no presumption of reasonableness here, but you still have to have a showing of substantive unreasonableness. So that's kind of a high bar. But in this case, as I pointed out, because a lot of the sentence doesn't seem to be tied to the 3553A factors, or at least there's an argument that they were not. It's entirely possible that a court could look at this and determine that it was not reasonable to downward depart so significantly. We're also talking about the Fourth Circuit, so depending on the panel, as with most circuits, that's going to potentially dictate the outcome. But certainly, I think it's worth a shot, and the Department of Justice is pursuing that, and we'll just wait and see what happens.
Thanks. Carrie, you've worked on issues surrounding the integrity of the federal judiciaries for many years. Maybe I could ask you some questions about the intersection of political violence and the independence of the judiciary. First, what are you seeing in terms of threats to the judiciary and to judicial independence in recent years?
Yeah, as you pointed out, and as the Chief Justice has been concerned about, as the marshals have flagged, these threats are only going up. And really, it shouldn't be surprising when we've seen the concerted efforts to attack the integrity of the court in the media, to try to push down favorability ratings with the court in and of itself. Obviously, we saw that kind of media circus surrounding nominations and hyperbolic language with Justice Kavanaugh in particular of how this was going to be the end of everything as we know it. If he was confirmed to the court, obviously way overblown, not true, but that type of effort on the front end to block a judge from being confirmed. Then once they're on the court, they have life tenure. We've seen a steady drumbeat and a pattern of people trying to then undermine the court in the eyes of the public in order to kind of downplay the respect for the court, given the fact that there are people on the court that they may disagree with. And that spans from just people, disrespecting their opinions more broadly to the really serious efforts of actually trying to assassinate justices. We've had members of Congress who applauded, for example, people being hounded out of restaurants. Being a Supreme Court justice shouldn't mean that you never get to eat out again, or can't eat out without people spitting at you or protesting outside. But that's been, cheered on by the Democrat establishment, unfortunately. Justices should be able to feel safe in their homes, particularly those justices like Justice Kavanaugh and Justice Barrett who have young school-age children at home. And yet we have seen federal law that is protecting them go unenforced during the Biden administration when these protests, regular protests at all these main justices' houses it was going on all the time. And it was just completely ignored by the federal government rather than actually enforcing those laws that were in effect. You had people doxing the justices. I didn't see ever any major follow-up on that as a major assault on the judicial integrity. So this is something that is continuing to worsen. And I think obviously the assassination attempt was the peak of it so far, and God forbid it would get any worse. But I think this is part of a pattern of political violence that we've seen in our country, that if we don't do something to push back on it, and unfortunately, I think there are a lot of politicians that aren't doing what they could do and using the megaphone that they have to say, hey, this is not appropriate. I could disagree all day with what the court does, but that doesn't make them evil. That doesn't equate them with Hitler. That doesn't mean they should be killed. And I think we can't also forget how significant the fact of a leak was. Having clerked at the Supreme Court, the idea of someone leaking a full opinion like that was just really unthinkable. In the immediate aftermath of hearing this announced, I was talking to other former clerks that I knew, and some people, despite the fact that this is like a 94-page opinion, very detailed, were just dismissing it out of hand because it was incomprehensible to them that anyone who is clerking at the Supreme Court would leak that. And obviously we don't know for sure it was a clerk. That seems to be the assumption, but the court is the one institution in DC that doesn't leak. This assassination attempt shows us why it's so important that it does not leak. I'm grateful that we haven't seen a repeat of that specific leak, although we have seen other internal information that's come out through the press, whether that's through other clerks, whether that's justices, I don't even know. But that shows a disrespect for the institution that I am very concerned about is in terms of this whole progression. And I hope that I think it would be much better if we had found the leaker there. At least in Roske's case, we've found him. He should have been brought to justice, I think. And unfortunately, I don't think 8 years sentence amounts to justice in this case. But I think you're muted.
I said, thank you. I said, Carrie, I think you're 100% right about how devastating leaks are to the integrity of the court's processes, both because they open the justices up to danger, but also because the deliberative process within the court is so important. It's so important that people be able to have a free exchange of ideas. And there are so few institutions left where you can really do that. And knowing that sort of preliminary ideas are not going to be leaked to the press and sort of held against you is a huge part of that to me. So we have a question from the audience, which is similar to a question that I was going to ask, which is, I was going to ask, what can be done to stop leaks or investigate and catch leakers? And one of our questioners asks, why hasn't the source of the leak of Dobbs been discovered? Has that ship sailed? Is there that person is just not going to be found at this point?
I think, from what the justices have commented on and my understanding of the process, internally, there's a general assumption that people know who it is, but what Justice Alito said is there's not, it's not evidence beyond a reasonable doubt, basically. And I think the assumption is to publicize that may destroy the career of this person, which frankly, if it's true, is warranted, because that type of breach of confidence flies in the face of one's ethical obligations as a lawyer, obviously. So I think that that's a real concern, that the person who did this, if they are a clerk, just went off and got, a 6-figure bonus and is working at a firm somewhere, and really is someone who doesn't have the ethical standards requisite for this profession. But I think the court, without having firmer evidence, is concerned about the potential of destroying someone's career if it were incorrect. I am just feel like at this point, I'm not sure there's anything more they're going to do to find the leaker. I think the moment to do it was immediately thereafter. And I think that the resources that were given to that just weren't equal to the job, unfortunately. I think there should have been more done at the moment. I'm hopeful that it just in the fact that we haven't seen one since then, I hope the court internally has taken more precautions in terms of, watermarking documents somehow, or having a better chain of custody ability to trace. When, I now feel really old here. Back when I was clerking at the court, you certainly couldn't leave the court building with any information that was private. You couldn't take anything home on a disk or a drive or a flash drive or anything. You shouldn't email them, but I don't know that they had the safeguards to prove that you weren't, they weren't checking your backpack on your way out of the building or anything. And I'm not sure they do that now, but I hope they've taken additional precautions to make sure they could at least trace it if something like this did happen. And, that kind of loops back around, because I think the deterrent factor of having a serious consequence, that's something we lost out on there by not finding out who it was. And that's unfortunately what's being sacrificed here as well. If the message being given to the public is attempting to kill a Supreme Court justice, and not really one, but he said he was shooting for 3, but the sentencing document said he Googled the addresses of 4 justices. So, I mean, the impact that could have had if the marshals hadn't been right there. Remember, there were debates at the time about whether whether we should even amp up security, and Congress was very slow in allocating funds for that. Oh my gosh, can you imagine if they hadn't done so? This could have gone a very different direction.
Here's another question from our audience. Rachel, this is maybe geared more towards you, although obviously anyone should feel free to answer. Shouldn't the sentence be lessened so that the criminal is incentivized to turn himself in rather than go ahead with the assassination? If the criminal thought that he would be sentenced to many decades in jail, he might have gone ahead with the assassination, figuring that he didn't have that much to lose.
It's hard to say what could or would happen, but I think that, all the other aspects of this crime, I think, outweigh any consideration that should have been given for turning himself in. This was, like I said, so serious in regard to, I would urge people to go look at the government sentencing paper here. And it really does an effective job at the very top, laying out some of the most egregious things that Roske said on Discord channels and direct messages about, removing, as Carrie said, not just one Supreme Court justice, but maybe 3 others. There were, what he believed to be addresses in his Google Maps. He bought guns. He had all of these things. And, it's hard to know what was in his mind at the time he decided to turn himself in. But to me, that seems a little bit calculated. So sure, he confessed, but I don't think that outweighs all the other aspects that a court should consider when determining an appropriate sentence. And, one thing just to point out here about deterrence, to Carrie's point, and I haven't worked for the government for some time. I have no idea what's going on, but for all of 2023 and 2024, there were merely status reports in this case saying the defense was still investigating the government's allegations. It was one after the other after the other. And I suppose some plea negotiations were going on at that time, but I prosecuted complex cases with multiple international defendants, and I've never seen anything like this. A delay, this individual confessed, as the questioner pointed out, was caught red-handed. Why did it take 3 years to prosecute this case and to come to a resolution? That is It appears to me that perhaps, the prior administration didn't have an appetite to pursue this and to come to an efficient resolution. But that affects deterrence of, value as well. If someone's waiting 3 years to get a sentence and then to get one as light as this one, it sends a message to everyone involved that this wasn't as serious as it actually was.
Just to follow on that, the acceptance of guilt was already part of the calculus of that 30 years to life sentence. And so it's not that that shouldn't count for anything. I'm very glad he turned himself in. Remember, he turned himself in after his sister, if you're talking on the phone to his sister convinced him to do it, and only after seeing the marshals in front. So we don't really know the contrapositive of what might have happened if all of those things hadn't happened. I'm glad he did ultimately turn himself in, and he did get some credit for that in the sentence. And also, that sentence could have been up to life in prison. So 30 years is still giving credit for that downgrade by saying, all right, you're not going to get life in prison, which for a young man, obviously, like him, very long. But to go down so dramatically below that really is a slap in the face to the justices who were at risk here, and any judge who wants to make sure that they're being protected adequately by our laws. This was an act of domestic terror, and I think that would have been an appropriate calculus to include in there as well if you're thinking, do we go higher or lower in the range? And that's something Judge Boardman just ignored.
It's interesting. We don't have the sentencing transcript yet, but from news reports and from sort of secondhand accounts, I was not there, but from people who were there, it sounds like she took into account kind of 4 different things in varying downwards from that 360 months to life. One of them is the factor that our listener has identified, which is the sort of abandonment of the plot. And to me, that seems like a really appropriate thing to take into account, both because it is a mitigating factor, and because that is something you want to incentivize. The others are the what Rachel was pointing to before, the kind of the transgender status and the mental health issues in terms of how that would play out in prison. And then the other 2 I think are very interesting. So one is the terrorism enhancement. The judge sort of sides with a couple of cases that on my reading are sort of outlier cases that say that the terrorism enhancement is higher than it should be, or at least should not impact criminal history, because it isn't based on sort of like evidence of recidivism. So the way the terrorism enhancement works, not to get like too nerdy about the guidelines, but the terrorism enhancement does 2 things. It adds 12 levels to your offense level, and then it automatically takes your criminal history category from category 1 to category 6. And what these kind of 2 cases that the defense cited and that the judge seems to have picked up on have said is, gosh, they don't like that part about the criminal history, because they think criminal history should just be about recidivism, and they don't think that there's a tie-in between terrorism and recidivism. I think there's kind of 2 interesting, or maybe 3 interesting points there. One is that in this case, it didn't actually make a difference what the criminal history category was for Roske. No matter, his offense level was so high that whether he was criminal history category 1 or criminal history category 6, he was still at 360 months to life. And so as a result, Judge Boardman had to go beyond where these 2 outlier cases go and make the, take this recidivism argument both to the criminal history part of the terrorism enhancement, but also to the offense level part. So I think that's interesting. I mean, I think one thing that to me seems, and I'm not speaking for the commission here, but I'm speaking for myself, I don't think that these enhancements, even to criminal history, are just about recidivism. They're very much about the different purposes of sentencing, including accounting for the seriousness of the offense, so the sort of just punishment aspect, and both the specific and the general deterrence points. So certainly there are things that the commission does that are very empirical based, where everything is driven by numbers, but there are also policy decisions that are made. And instituting the terrorism enhancement is one of those that was really much more policy based. It came out of a directive from Congress. And frankly, terrorism just isn't an offense that is committed in numbers enough for there to be very robust data. So I think last year the terrorism enhancement was implied something like 38 times. So that's not it's not like fraud or drugs, where we have really robust regressions that show you, to a high degree of certainty where you get links with recidivism. It's the kind of thing where you really have to go with a policy judgment. And so certainly there are not studies showing, oh gosh, recidivism and the terrorism enhancement are not linked, but there aren't robust studies showing that they are linked either. And that's why it's something that was decided more based on policy. Okay, let's go to our next question. Were other individuals indicted for conspiracy, or was Roske acting alone? Can you explain the legal considerations that factor into a downward deviation from sentencing guidelines? Does anyone want to hop on that? So my understanding is he was acting alone. I know he was speaking online with a number of friends on a Discord server, and sort of chatting with those friends, but I don't think they knew what he was planning. He was just sort of bouncing ideas off of them. Gosh, what would happen if one of the justices was killed? How many justices would have to be killed to change the balance on the court? And I know that he tried to wipe his hard drive of those things before flying to Washington. But I don't think that anyone else was in on the crime. Does anyone else have another view?
I've not seen any evidence of there being anybody else involved.
And then in terms of legal considerations that factor into a downward deviation from the guidelines, I guess we talked about that a little bit about the.
And I'll just add that typically transgender status is not on that on that list. That's the other. I mean, we talked about incentives, and let's have a sentence that incentivizes the behavior we want, which is a part of with the way the guidelines work, right? We want to incentivize good behavior, but the incentive created by the way that Judge Boardman decided to employ his transgender discussion was really, novel and risks creating very bad incentives throughout the system. Now, I think we're in a better position now that President Trump has said men are going to be housed in men's, women are going to be housed in women's prisons, because before that, when there were people being housed, cross-sex in prisons, it was a serious problem and risk to women in women's prisons, because there were rapes happening, there was assaults happening. It's a very dangerous situation to put female prisoners in. So that at least removes an incentive that someone might have to try to get in a potentially less intense environment by trying to get into women's prison. Now we've created an incentive where claiming transgender status, and look, I don't know, I can't speak to Roske's sincerity here. He may be completely sincere, but do we want to create a situation in which claiming transgender status now is literally a get out of jail free card? Like, you cut years and years off of your sentence if you can convince the judge that you are transgender. I think that's a dangerous set of incentives to create, and unfortunately, I think that's what Judge Boardman may have done here.
Next question. Could this sentencing appeal land before SCOTUS? Would Justice Kavanaugh have to recuse? What about the other 3 potential targets Roske has identified?
I assume he would have to recuse, and they've intentionally not been clear about which justices it was. We all have a guess, pretty solid guesses as to which 6 justices he might have been targeting, right? And so I would assume they would have to recuse, which does assume if it even was something that appealed there. It is, as Rachel said, it's a weird type of a question. It's because there are certainly legal aspects to it, but lower court judges are typically given so much discretion in this area that it'd be unusual for this kind of thing to get to the Supreme Court. Particularly in this case, we would say it's maybe not the best vehicle to discuss whether these types of downward departures are appropriate, because you would have so many justices recused. And you could also run into, I think you need 6 justices for a quorum, right? So if you really all of them recused, and there were 3 additional ones in addition to Justice Kavanaugh, that could be a real problem. The challenge in appealing it highlights also to me just a reminder for the importance of judicial selection and judicial nominations, not just at the Supreme Court, but at the appellate court level and at the district court level. District court judges have an incredible amount of discretion at their hands in terms of sentencing, in terms of evidentiary questions, in terms of a lot of different motions practice that never is really fully reviewed by the appellate courts, or let alone the Supreme Court. And so we have to remember that these aren't throwaway positions by any means. They're really serious part of maintaining the rule of law is having lower court, district court judges who are doing so, and appellate court judges, obviously, who are going to be consistent with that as well. The Fourth Circuit, I laughed almost recently because there was a newspaper article that was commenting on some Fourth Circuit decision, said, well, the traditionally conservative Fourth Circuit, they were trying to kind of bolster that opinion as a conservative opinion. I'm like, maybe, 30 years ago, but
when
not
we were in law school. Yes.
not today, not today. So that's not a court that I would say is terribly likely to be one that's pushing back as much as some others might on this type of sentencing.
And I guess there's two of those decisions highlighted here that have those deferential standards of review. One is the sentencing decision overall, the decision to vary, as Rachel highlighted before. And the other is the sort of the finding of fact made about the reason for abandoning the plan, right? I think when you look at the kind of evidence, which I've, not dug into as much as the judge has, I'm sure, but like when you look at the evidence, I think you can tell a story that this defendant abandoned the plan because of seeing the marshals and getting spooked. You can tell a story, which the defense tells in their papers, that the defendant saw the marshals, thought, oh gosh, this is much more real than I realized. It's about a person, not an idea, and changed his mind and affirmatively abandoned things. And this, from news reports, this judge seems to have made a factual finding on that, which would get a very deferential standard of review on appeal. Okay, so this goes along with what Carrie was just saying. The focus thus far has been almost exclusively on threats against Supreme Court justices, but threats against district court judges and circuit court judges are also on the rise. What can be done to reverse these trends?
Well, I think prosecuting these quickly and aggressively is one way to start, to send a message that the federal government is going to allow for this to happen. I mean, one of the things this brings to mind is the protest at the justices' homes. I believe it was in the past couple of years. I think there might have been one statement by Roske that he determined the location of one of the justices' homes by looking at pictures of protests outside of his house. The fact that those protests were allowed to happen at all is a problem. And I think it led people to believe that attacking justices personally for their views and decisions was acceptable. So I think really cutting this off at the beginning and drawing a hard line about what is and is not going to be accepted is one way to start. And also, again, when this does happen, unfortunately, and thankfully it was not accomplished, but when somebody does try to take steps, and as many steps as Roske did, holding them accountable for the seriousness of that behavior is great start.
Yeah, and remember, there's the violent attacks, but then there's also just the level of protests that have been tolerated and in many cases even encouraged by those who are in positions of authority. I think of like Kyle Duncan's speech at Stanford, where you had the administration of the school standing up and trying to defend students who were shouting down a federal judge coming to speak at their campus. I think what we really need is a change in the culture so that we can understand you can disagree with someone and have a debate and not resort to the extreme on the speech end, which is just shouting them down and trying to block their speech, or obviously absolute hardline on the extreme of ever taking any violent action. But until we are as a society willing to just say this type of behavior is out of line, we cannot have people speculating about maybe I should kill my political opponent, which we're unfortunately in Virginia here, where we have a attorney general candidate has said this is just the kind of discussion that's, even if it were purely a joke, not appropriate. And God forbid, anyone making these kind of statements or using that kind of language. I think we just need a across the board cultural rejection of that, and that really requires leaders on all sides of every aisle to stand up and say this is something that we're not going to stand for. I do think there's a small change, at least in campus life, of improvement since Kyle Duncan's attempted speech, but it's still, I'm not sure that the change has been as dramatic as it would like to be, as people would like it to be. I had sort of hoped that at least that would be a silver lining of the assassination of Charlie Kirk is that everyone would realize and stand up and stand together and say, wow, okay, that was way too far. And there were a lot of people who did, but I was really shocked by the number of people who not only were thinking, yeah, he got what was coming to him, but were willing to say so in a public forum online, put their faces to it and say, no, no, yeah, I'm totally down with assassination of my opponents. Yeah, like, wow, that is a, so I think we just need to all work together to change those cultural assumptions, because that's what's making this kind of crime even thinkable is the first problem.
Several follow-up questions about violence directed at other judges. So people are interested in whether we know whether, obviously Supreme Court justices often have a detail. I don't think they have to have one, but they are afforded one if they'd like one. Do we know if Court of Appeals judges or district court judges are offered that? Do we know about the incidents? I can say a little bit about incidents, just sort of anecdotally. People probably remember in 2020, New Jersey District Judge Esther Salas's son was shot and murdered at her home by a disappointed litigant. I know that there is right now an arson investigation going on about a South Carolina judge, although I think that I just read an article. I don't know if this will be the end result, but the preliminary result was that maybe it's not arson. I know that Justice Barrett just recently has spoken very publicly about bomb threats her sister received and these pizza threats that she and other members of her family have received. These pizza threats are, late at night you receive a pizza you didn't order to your doorstep. And it's a way of someone who is hostile to you showing that they know where you live and that they could get to you if they wanted to. Just purely anecdotally, the commission has workshops with judges, and I've heard from other judges that they either have received the pizza or know of other judges who have. Does anyone have any insight into protective measures for non-justice judges?
I mean, I can just speak generally, and Carrie, feel free to jump in. But I mean, I think every district court judge I know, and I assume circuit court judges as well, have the marshals to support them. Security kind of reviews are done of these judges' homes. If you're traveling, you can alert them to that. So there's certain steps that are taken. I don't know of any other, instances of threats, but clearly there have been. I think the marshals are tracking this, and so I think it was in 2015 there were like 900 incidents, and in 2020, I think it was 2021 or 2022, it had gone up to 4,500. So clearly it is happening.
Yeah, and I'm not sure any of the other judges have default security detail in the way that Supreme Court justices do, where they're just tracked everywhere they go. I think that's probably done on a case-by-case basis based on, if there's active reason to be concerned. I think that's something that Congress needs to make sure they are adequately allocating money so that the marshals do have the bandwidth to protect our federal judges. It's as public servants, they shouldn't be having to put their safety at risk in addition to just using the remainder of their career on these life tenured positions in public service.
One commenter asks, are we aware of cases in which actual or threatened violence has caused judges to resign, or in cases in which it's caused nominees to withdraw their name from confirmation or chilled their decision to go through the confirmation process?
I think, frankly, I think a lot of the stuff we've seen during these confirmation processes, in addition to these threats, is maybe intended to have that kind of chilling action. I think if you, once upon a time, it would be just, oh, wonderful, I've been nominated to a seat on fill in the blank court, and this is a great, there'll be a good career move, et cetera. But now anyone considering a federal position at any level has to take all of that into account. Am I willing to put my family through the added security risk? Am I willing to put them through an increasingly politicized confirmation process, particularly in light of some of the smear campaigns we've seen and really scurrilous allegations that get thrown around? Again, Justice Kavanaugh's confirmation, just one example. Justice Thomas's, obviously. You saw attacks on everyone, but some were more successful in drumming up media than others. So I do think that's probably part of the calculus. I hope that our best and our brightest are still stepping up and being willing to serve. But remember, this is anyone who's in a career level where they would be considered for one of these courts is also taking a significant pay cut. They're also, it's a very big change to one's practice and one's life to do this already. So I wish that security didn't have to be part of that calculus. I'm sure there are some people who have said, this is just not worth dragging my family through this gauntlet. But I hope that we can continue to stand against this so that that's not, people don't have to pay that kind of cost.
Yeah, I was going to say something similar to what Carrie said, which is I think it's kind of a multi-factor balancing test for most people in deciding whether or not to throw your hat in the ring on that kind of thing. And I don't know of people who have explicitly said, oh gosh, I'm worried about the risk of violence. I do know people who have said, I don't want to drag my family through this, mostly because of the ugliness of the confirmation process. And it would not surprise me if this factors into the mix. Okay, let's see what our next question is. What do we think is the source of the current culture in which political violence is condoned and respectful debate is rejected or undervalued? It's a big question.
I mean, there are so many factors going into this. I think, to diverge from what, this commenting on culture is sort of not really the FedSox thing, but I think part of it is we're living in a post-Christian culture where we used to kind of have a shared Judeo-Christian set of understanding of these are the ethical and moral standards that everyone's living by. And as a society, we don't really have that kind of background that people can then relate back to. We maybe ran on the fumes of that for a while, but I think at this point, that's probably not there as a backstop for a lot of people. Obviously, the advent of the internet makes it even easier for people to say hateful things without having to look someone in the face and say it. And so that makes it easier to make these kind of allegations. And the whole thing has a coarsening process on the culture, because even if people are just willing to hyperbolically say things they wouldn't have said before, then the next person who reads it might be just so inundated with this type of background noise that it almost moves the Overton window of what they could consider being possible in their head. And then you've got people who really do have mental issues who then start saying, oh, well, actually, I'm going to take action on this. And unfortunately, if you read the statistics, it's not just people at the extreme who are experiencing mental instability who are taking the idea of political violence seriously. There was that survey recently, I think it was college campuses, and 34% of students, or I don't remember if students or Democrat students, but either way, it's a shocking number, said it was okay to engage in political violence. Like that's the kind of background. Again, with when there was a clearer background morality in American society, even if you thought that, you would realize you shouldn't say that out loud. And hypocritical as that may be, not saying it out loud helps other people not think it's a good idea too. So once you start breaking that down, then you have the whole system encouraging people to say, okay, maybe political violence isn't something that's really off the table. I mean, it's funny. It used to be a really challenging ethical question. If you could go back in history, would you kill Hitler? Because everyone had such a bedrock assumption of, wow, you even to prevent something as horrible as World War II, the Holocaust, everything, you can't directly take a human life, right? That question is not, it's not a hard ethical question nowadays. If you kind of think that even a person staring me in the face, I can, attack them, even kill them just because I disagree with their opinion. Someone who is objectively not killing millions of people. I mean, that's it. We need to try to figure out, I don't know how to put the genie back in that bottle, but it's definitely not a great cultural direction our country has gone. And I don't know the legally what you can. I think there's a limited toolbox of how the law can address the issue if it's fundamentally a cultural issue. So there's only so much we can do as qua lawyers. It's a little bit of a limited toolbox.
There is also, just like tied in with your internet point, there is these sort of like bubbles that people get into where their algorithm is feeding them the same things and nothing that challenges them. And so people get in their little silos and they can find people who think exactly what they do and they all get more extreme. And people kind of get out of the habit of getting into debates and having friendly conversations with people and have those same feedback loops. I also think that just over the course of our lifetime, you've seen challenges from the left and the right to sort of like classical liberal notions of the marketplace of ideas as the place where things are hashed out, and both the left and the right sort of calling into question whether the marketplace of ideas is adequate to that task in a way that sometimes can make people look for other answers.
Yeah. Then the loss that you talk about, like knowing other people and giving them the benefit of the doubt, the loss of our just a culture of having any shared spaces other than these, internet silos that we get into. I remember speaking on a panel years ago. It was right when Justice Gorsuch had been confirmed, and one of the Democrats in the panel thought Justice Gorsuch was a horrible, evil person, but then said something actually very positive about Justice Alito. And afterwards, I talked to them. I'm like, you realize their judicial approach is not dramatically different. Like, why is it that you assume Justice Gorsuch is so horrible and malintentioned, and then Justice Alito, is just kind of maybe confused or misguided? And she said, well, to be honest, I know Justice Alito because our kids went to the same school. There was some like neighborhood connection or something like that. And so not losing this civil society that we used to have in a more robust way, where your neighbors or people of differing party or political things because you're at the same school or the same church or the same, all these different civic organizations gave you the ability to see those people as human beings rather than just as masks for this opposing ideology. And so so she was able to see that Justice Alito, like, well, I'm not, I don't agree with his approach. He's probably a nice person and just as misguided. And then the opposite about Justice Gorsuch, I think that really was telling to me.
Okay, well, here's one I probably should not answer as a member of the judicial branch, but could Chief Justice Roberts do more to address the issue of aggression against judges? One thing I will say is that I know that this is, as I mentioned, extremely top of mind for the judicial conference. It's something that gets widely discussed within the branch. I think there's a lot of focus on it. I don't know if anyone has any thoughts on that.
He's spoken on multiple occasions. I mean, the Chief Justice has a limited amount of leverage that he can bring. He's got the bully pulpit, but much less so than other areas. I don't know. I believe he's asked for more funding for the courts and the marshal's office. I don't know, Rachel, if you have any ideas of things he could do.
No, I would hesitant to speak at what more he could do. I agree with you. I've seen him make some comments already. So, I think it probably is going to take a lot more than that to turn this around, unfortunately.
To be honest, I think the Chief Justice probably has even though he's chief, might have less that he could do. That I think if you saw like a joint concerted vocal effort by Justices Sotomayor and Kagan and Jackson, maybe to say, guys, this is insane. And to some extent, we have already seen. I mean, Justice Sotomayor recently, I think, was on a panel with Justice Barrett, and they were trying to talk about it. And even when she was in The View, she's like, "Look, go back and read the opinions. Like, it's not as extreme as sometimes you guys portray it." So they've done that to some extent, but I think their voices might at least be taken more seriously by some of the voices on the left that are advocating for it, more so than the Chief Justice. So I don't know.
This commenter wants to know, is there a way to tone down violent political rhetoric without infringing on First Amendment rights?
I guess it depends on who's doing the toning down, So, like Carrie said, I guess, we're not really focused on culture here per se at Federal Society, but to the extent that, communities can start being communities again, and there's some sort of reinforcing element to an accountability that comes from meeting people, apart from and aside from being on the internet. I think that it takes, I think there's absolutely ways to encourage people not to engage in violent political rhetoric that doesn't at all offend the First Amendment. Yeah, I mean, there's speech over here, and then there's violence over here, and I think that there's a lot of room in between that doesn't require infringing on one to prevent the other.
And as Rachel pointed out, like just the deterrent factor of when actual, because obviously violence is not protected by the First Amendment. So when there is actual violence that is carried out, the swifter the response to that can be, I think that at least is helpful and obviously doesn't impact First Amendment.
Okay, this might be the last question we have time for. Given the backdrop of the mentioned, quote, political violence polls, this case and current events, there appear indicators of a growing public perception that the courts are no longer serving as neutral arbiters of the law. What steps can the judiciary, consistent with its tradition of restraint and fidelity to the Constitution, take to restore public confidence that justice is applied fairly, that the rule of law remains above politics rather than subordinate to it? So basically, what can the courts do to ensure that there is good confidence in the courts and the judicial system, and that there's one standard of justice?
I mean, I think that they can apply the law. I mean, that's step one, right? And another thing, I think a lot of judges take this seriously is, you know, and in this environment, it might not be something people have a huge appetite for, but I think having lower court judges be more visible to the public generally is not a bad idea. You know, speaking at public events, you know, speaking at civic, you know, occasions, I think is important to not only humanize them, but to, you know, make other people feel heard, you know, and to explain kind of what they're up against and to talk about the judiciary generally, I don't think is a bad idea. You know, but I think hewing to the rule of law and applying that and doing that day in and day out, it's a job that a lot of people don't see. They only see, you know, the big opinions and the big decisions that people disagree with a lot, but I think doing that every day is really important. And so it's important who we choose to be our district court judges.
I think one other challenge here is what the judiciary can do most to promote the rule of law is just to engage in the rule of law and behave according to the Constitution, make sure their decisions are based in law and not in politics. But a large challenge is the fact that the public perception isn't always is based on what the media are telling you sometimes, and not actually based on, you know, people looking at the opinions themselves. So even if we have judges who are perfectly obeying the rule of law, and I don't think we do, then you also have to deal with the fact that I think we've seen a concentrated media campaign trying to attack certain justices and saying, well, they're threats to democracy, et cetera, and not following the rule of law. At the same time, I do think there are real instances that of lower judges. Certainly, we've seen a lot of pushback in terms of the injunctions against this administration and on the emergency docket and things like that. Some of which definitely seems to go above and beyond what a normal judge's role is. And I think every judge needs to make sure he or she is keeping within those bounds as much as possible, while also not allowing that public pressure and the opinion poll kind of push to change their decisions either, because that ultimately would be a victory for people who are trying to get politics to be the arbiter rather than the law itself.
Wonderful. Well, thank you so much to our speakers and to Claire for moderating. If you are interested in learning more about Federalist Society programming, please visit fedsoc.org. Thanks, everyone.